Okay, I guess that means we're supposed to start our panel. Can you hear me now?
I can hear you.
Okay. All righty. So I guess we're gonna begin our panel. And we're happy today to have here for the entertainment law panel for this combined Microsoft and Institute for Intellectual Property CLE event. This is the 18th annual event for the Institute for Intellectual Property and Social Justice, and I believe it's the third tech law summit for Microsoft. That's was typically held at Howard University, but of course we're doing it virtually, and I guess we're using Microsoft Teams as Microsoft is obviously part of one of the co-presenters of today's event. We're happy today to bring some very relevant and timely issues in the entertainment space. My name is Lita Rosario Richardson, and I am the principal at Lita Rosario PLLC and Wise Girl Entertainment Consulting. I'm a 1986 graduate of Howard University Law School, and also happy to say I'll throw in a little comment that I went to Howard undergrad as well with our Vice President Kamala Harris, and I recruited her to the Howard University debate team while I was in undergraduate school. So just a little shout out for that. And I started practicing entertainment law very early on in my career after going to Wall Street and doing mergers and acquisitions in the Michael Milken hostile takeover era. And I've done a lot in copyright law, mostly in music, a bit of transactional work in litigation. And I'm very happy to introduce two gentlemen that I have known for quite some time, Robert Bernstein and John Simson. And I'm going to give you a little background about Mr. Bernstein and Mr. Simson, and then we will get started in our program. So Mr. Bernstein has practiced in the field of copyright and trademark litigation and counseling for many years, and has also dealt in the areas of unfair competition, publicity, licensing, and of course, contract negotiation. He clerked for U.S. District Judge Richard Match, I think is the name, in the District of Colorado. And importantly, he served as president of the Copyright Society from 2000 to 2002 and had chaired many of the committees there as well. He has been the co-author of the New York Law Journal copyright law column for 35 years and has done that with David Goldberg and now with Robert Clarita. He's lectured and been on many panels for many different bar associations and bar associations and other organizations, law schools, etc. He now is practicing with his own law firm, and he has been involved in several reported cases. Today, Mr. Bernstein is going to talk to us about the recent decision involving Dr. Seuss and the issue of fair use. I'm going to open it up to him in a second, but I'm just going to introduce Mr. Simson now as well. And I've known John Simson now for quite some time as well, dating back, I guess, first of all, to my early days at University Music Group, a record label that I co-founded that signed an artist named Maya. And Jay Rosenthal and John Simson I knew for quite some time. Unfortunately, our colleague Jay Rosenthal has passed, and we're all very sad about that. But John has a long and stellar career as well. He is now at Fox Rothschild as of counsel. And he also co-founded Sound Exchange, the company that collects performance royalties from internet and satellite radio services on behalf of recording artists and record labels. John handled the career of Mary Chapin Carpenter and Harry Belafonte in music and TV projects. He previously taught at the Washington College of Law and Georgetown University Law Center. And he has numerous awards, including Emmy nominated for music supervision of the PBS series American Roots Music. He also is the founder of the entertainment program at American University's Kogod School of Music, of Business, I'm sorry, and where he actually brought me on to be an adjunct professor there. So very happy to have John Simson here as well. So we're going to get started with Bob Bernstein's presentation on this very timely case involving the Dr. Seuss and the question of fair use.
Thank you. Thank you, Lita. Can you all hear me?
Yes.
We're not sharing the screen yet. Is somebody just?
Yeah, not quite time to share the screen. We'll
No.
let you know when it's time. Okay.
Okay, so it's a privilege and an honor to speak at a conference sponsored by the law school that has as distinguished graduates our vice president and Lita Rosario, and I appreciate the invitation. So the Seuss case, Dr. Seuss case involved whether a parody of one of his most well-known books called "Oh, the Places You'll Go" was used fairly in "Oh, the Places You'll Boldly Go." Now, the authors of "Oh, the Places You'll Boldly Go" claimed it was a parody, and they lost. They actually won at the district court level, but in the Ninth Circuit it was reversed, and there was a very thorough discussion of fair use in the context of parodies. And it's interesting to note that there are at least two other important decisions involving Dr. Seuss concerning fair use. One is Lombardo versus Dr. Seuss Enterprises, which was in the Southern District of New York. It was a case in which a play, which purported to be a parody of The Grinch Who Stole Christmas, which is one of Dr. Seuss's most famous books, whether that play was a parody and a fair use. And unlike in the Penguin case involving the cat in the hat versus the cat not in the hat, which was the Penguin book, and unlike the Ninth Circuit case that we're discussing now, which I'll refer to as Comics Mix. Comic Mix is the defendant. And by the way, that case has been remanded, and this morning, California time, there was a status conference on it. I'm not involved in the case, but I keep looking at the docket sheet from time to time. And so I think they're going to be dealing with issues like costs, but there's no more legal issues in the case because the Ninth Circuit affirmed the trademark dismissal and reversed on the copyright fair use issue. So the legal issues are resolved, and as far as I know, there's been no request for a petition for rehearing. I think you have 90 days to do that. The decision came down, I believe, in December 18, 2020. So there's still time to file a cert petition, but I doubt there will because it was kind of a resounding defeat on fair use, and it was pretty well reasoned. So Dr. Seuss is 2 and 1, and the purported fair users are 1 and 2. So let's discuss first the recent case decided in December. in that case, well, let me describe the works in that case. And here I will read a little bit from the judge's opinion, because he expresses it more poetically than I can. And also, it's interesting that he's done that, because a number of judges have been tempted to write in prose and poetry very creatively when they have these cases. They get inspired. I think Judge Kaczynski once wrote an entire opinion in a trademark case, a right of publicity case, in rhyme. So Dr. Seuss's book closes with this note of caution, and it basically is about a young man about to go off in the world or graduate high school, and he is there's a narrator who takes him through a whole bunch of experiences to show that, in Dr. Seuss's words, I'm sorry to say, this is the ending, I'm sorry to say so, but sadly it's true that bang-ups and hang-ups can happen to you. And then he goes on to say, if he were alive today, Dr. Seuss might have gone on to say that mashups can happen to you. And that is because the defendant's book, called same title as the plaintiff's, but it adds the word boldly go, was basically directed to the same market of graduates, and it's one of the very best-selling books during graduation season. So the protagonist basically goes through a number of setbacks, overcomes them all, and the message is that Dr. Seuss is giving out is, don't be shy, go for your goals. You may not, you may have a number of knockdowns on the way, but get up and keep going and things will work out for you. So that same theme is in the defendant's book, and it's structured the same. And it's basically, I would say that the structure and message and progression is the same. And it uses identical, in many places, illustrations. And the illustrations are set out in the same order, and they're changed because it's a mashup. But the only change really is that they've added Star Trek characters, such as Dr. Spock and the Starship Enterprise, and they place them instead of the characters in the book, but the illustrations, the backup illustrations, and even the shape of the people, it's all the same. In fact, in one instance, the illustrator testified that it took him 7 hours to replicate a complicated machine that Dr. Seuss had drawn, because he wanted to get it exactly right. So it may be that this shouldn't be a controversial case, but it's a lesson really that the first judge who looked at it said it was fair use and it was a parody. And the Ninth Circuit unanimously disagreed, which is typical of getting reversals on these cases, because very often the subjective reaction of one judge is not going to prevail if it's a complicated case. So let me take you through to see some of the illustrations in question, because I can't take you through the text, because the text of the defendant's book, Boldly, was filed under seal. No one can see it. So we don't know what the text is. We just know that they tried to make it flow in the same way and structure in the same way. But whether there was any literal use, we don't know. But because the illustrations are so central and they were, in many cases, exactly copied. They didn't really need to discuss the text. Could you put the PowerPoint presentation on, please? Can you enlarge it a little bit? Any luck? Stay on the first one, please. Good, that's perfect. Okay, I'll let you know when to move. So before I discuss this illustration, I should say that probably all of you are familiar with the basic outline of fair use, that it's codified in Section 107 of the Copyright Act, and that it's basically seeking to determine whether the use advances or does not advance the purpose of copyright. And the way that that is done is by going through the statutory factors. The first one is the purpose of the use, including whether it is for nonprofit, for criticism, for comment, news reporting, teaching, scholarship, or research. So parody falls into the category of criticism and comment. So that's a purpose that fair use is designed to advance. And there's four factors. The first one and the fourth one are the most important. So the purpose and character of the use is the first one. And on that factor, the Supreme Court in Campbell v. Acuff Rose held that whether a use is transformative, meaning whether it adds something new, changes the nature of it, gives new insights about the original work, is a key factor in factor one. Also, Campbell made clear that each of the factors is affected by the others and that it's a collective decision. And since they interact on each other, whether it's transformative or not is very key. And that is because under the third factor and the fourth factor, which are the amount and substantiality of the portion used, and the fourth factor is the effect of the use upon the potential market, whether it's transformative will affect whether those factors weigh in favor or against fair use. The second factor, nature of the copyrighted work, usually doesn't weigh one way or the other because it's not weighed heavily in any of the decisions. They just keep repeating that this factor is not determinative. The idea of that factor is that it should protect highly creative works, perhaps more than factual works, but it's just not weighed heavily in the decisions. So we look at the first illustration here in light of these legal standards. And as you're looking at it, I'm going to read to you what the opinion, the circuit court opinion, said about these particular illustrations. Most telling is Comic Mix's repackaging of Go's illustrations. The Star Trek characters step into the shoes of Seussian characters in a Seussian world that is otherwise unchanged. So essentially, there were no changes to the background or the shape of the characters, but to the extent that they were Star Trek characters, they were just placed in the illustrations in the role of the original illustrations, and they didn't serve the function of shedding new light or new insights about the original. Basically, the Star Trek characters inhabited Dr. Seuss's world, without commenting on it. And one of the issues was whether to have a parody, you had to comment on the original work. On that one, the judges held that the whole purpose of parody is to conjure up the original work enough so that you can either criticize it, make fun of it, use it in some way that could be deemed satirical. However, they did not rule on whether a satire that did not comment on the original work would be fair use. I think that's still an open question because the court only dealt with parody, which is a subset of satire and requires that the use of the original work involve commenting or criticizing it in some way. Satires, of course, don't need to conjure up any other works. They can just make fun of, President Ford or President Trump or a movie star or whatever issue is current, and they don't have to use another work to do that. But parodies, which are a subset of satire, do have to comment and criticize. So,
Bob, you have 5 minutes left, just so you know, of your 15, okay?
right, next slide, please. So you see here, these illustrations are pretty much the same. Here's what the court said about those. Comic Mix copied a scene in another one of Dr. Seuss's works down to the exact shape of the sandy hills in the background and placement of footprints that collide in the middle of the page. And I think, go on to the next one. Since there's little time left, I won't comment on it, but you have the opinion, it's in the slip opinion on pages 18, 19, 22, and 23. You can see the illustrations in color and the judge's comments. But essentially, the bottom line concluded is because Oldby left the inherent character of the book unchanged, it was not a transformative use. And also because it wasn't transformative, there was no need to use the original work, and they used a lot anyway, so that weighed against fair use. And on the market, that was an easy one because they were seeking the same market, graduates. They had the same message and theme, and Dr. Seuss also had many licensed editions, including some in which he mixed up his characters with characters from other works in a licensed way. So it was fair use, all 4 factors in favor of, it was deemed an infringement, sorry, all 4 factors in favor of the plaintiff. Now, just to conclude, in the 2 other cases, one was a play that used really a lot of the text and rhyming style of Dr. Seuss works, but it was done in a one-woman comedy in which they took the very wholesome Grinch Stole Christmas and turned it into an often pornographic or at least adult-themed work that the court viewed as commenting on the innocent nature of the Grinch, and that was viewed a fair use. And the Second Circuit affirmed that on a summary opinion, which means they agreed without controversy. And as a conclusion, I'll read the other, an excerpt from The Cat Not in the Hat, which was held to be an infringement because all it did is take some of what was in the original work by Seuss and use that to tell the story of the O.J. Simpson trial, and it did not add anything or comment on the original work. It just used it. So here's something that may be illustrative of the cat not in the hat. On the hiring of lawyers for O.J. Simpson, the defendant wrote, "A plea went out to Rob Shapiro, can you save the fallen hero?" And Marcia Clark, hooray, hooray, what was called in with a justice play. A man this famous never hires lawyers like Jacoby Myers. When you're accused of a killing scheme, you need to build a real dream team. Cochran, doodle doo. Johnny, won't you join the crew? Cochran, deedle dee. The dream team needs a victory. So authors like to call on Dr. Seuss's creative style and use it in their own work, but if they don't comment in some way on that style, it won't be deemed a parody and it won't be deemed fair use. I guess I'll stop here.
Right. Thank you, Bob. And maybe we'll have a little time at the end as well for you to address the trademark issue in that case quickly. We'll see how that turns out. I failed to state when we started out that this panel is going to obviously talk about this recent decision, the Dr. Seuss decision and the fair use issue. John Simpson is actually going to take the stage now, and he is going to discuss the implementation of the Music Modernization Act, which many of you should be familiar with. It had a number of components, and one of the biggest things that it was supposed to do is set up a royalty collection system for collection of royalties for songwriters from digital service providers and some others. It also dealt with issues regarding payment of royalties, sound recording royalties for pre-1972 recordings, and it kind of codified a practice that Sound Exchange has used to pay producers of musical recordings, master recordings, through a letter of direction or an LOD system. And finally, when John is finished, I'm going to give everyone an update on the class action lawsuits that are currently pending against Universal Music Group and Sony Music Entertainment for artists that are exercising their termination rights to terminate the grants of copyright to record companies in connection with master recording. So, John, I'll turn this over to you now, and you can give us some updates on the implementation of the Music Modernization Act. Thanks, John.
Sure. Thank you, Lita. As Lita said, the Music Modernization Act was actually an omnibus bill. It was the first time the music industry sort of came together and said, rather than having these piecemeal bills that get passed one at a time, let's all get together, sit at the table, and figure out if we can get one large piece of legislation passed. There was the Songwriters Equity Act, which was to fix a rate standard issue. There was the Classics Act, which was to get pre-72 artists, as most of you likely know, recordings that came out before February 15th of 1972 were not protected under federal copyright. They were protected by state and common law. And in the distribution of recordings, that wasn't a huge problem. Obviously, it was a problem in that we didn't have a performance right, a public performance right, so recording artists didn't get paid when radio stations and baseball players walk up to the plate and use their favorite recording artists who don't get paid a cent. So it wasn't really an issue, though, until 2012, when the Copyright Royalty Board ruled that these pre-72 recordings didn't fit within Section 114 of the Copyright Act, which gave a digital performance right to sound recordings. It said they're not federally copyrighted, so therefore they are not part of the system. SiriusXM and Pandora stopped paying for these pre-72 recordings, led to some class actions. Very quickly SiriusXM settled with the major labels on their content, but Flo and Eddie of the Turtles had filed a class action in Florida, California, and New York. In that case, still has some repercussions, but Congress was going to fix that in this Music Modernization Act. The AMP Act, as Lita referred to, the Allocation for Music Producers Act, was designed to it doesn't really change the sound exchange procedure because it only applies to recordings that came out before 1996 when the Digital Rights and the Digital Performance Right and Sound Recordings Act was passed. It's for those legacy old recordings where you can't track down the artist and a producer's trying to get paid. It did fix one piece, though, for sound exchange from a tax standpoint, but a very critical one, which was sound exchange. When I was running it from 2001 to 2010, we realized that in the industry, producers frequently got paid by the recording artist some portion of their royalties for the work they did producing the record. But producers weren't at the table when the digital performance right was passed. And therefore, in the statute, it said that 50% would go to the copyright owner, typically a record label, 45% would go to the featured performer on that sound recording, and 5% would be split by the background musicians and background vocalists. Nothing for the producer, who frequently, had a bigger hand than the background musicians and vocalists in making the record a hit. So we started a letter of direction program where an artist could sign a letter of direction, a revocable letter of direction, which the artist could revoke at any time, where the artist would designate Sound Exchange to pay a certain amount of money to the producer. Usually it was a 15% or 20% or some percentage of their royalties. But because the producers weren't mentioned in the statute, Sound Exchange, on advice of our financial advisors, the artist was the only earning entity and therefore had to get the full 1099 of the full amount. And then the artist, of course, would have to their accountants would have to work backwards and say, oh, well, we paid this much to a producer and therefore we shouldn't be taxed on that amount. This bill actually changes that. So the producers are now earning entities so that Sound Exchange could actually say, we paid this much to the producer, here's your 1099. We paid this much to the artist, here's your 1099. So a wonderful fix that. For the producers of those early recordings, I frankly don't think it was a great fix. Basically, if a producer can't find an artist to sign one of these letters of direction, they send Sound Exchange a note saying, can't find the artist, please pay me. Sound Exchange tries to find the artist. If they can't find the artist, they then will pay the producer roughly 2 points of those 45. Much, much lower than most producers would normally receive, and less than the background musicians and less than the background vocalists. So I think while it's a fix of some kind and acknowledges producers, not a great fix. So we had the AMP Act, the Classics Act to fix the pre-72 problem. There was another big bill in Congress that had been circulating for a long time, and that was the Fair Play, Fair Pay Act, which was designed to correct that problem about American artists, or well, any artist not getting paid by radio stations in the United States for airplay. But we realized that if we kept that piece of legislation in the Music Modernization Act, that the bill would get killed by the broadcasters because of their powerful lobbying influence in Congress. So that is one piece that was not included. And then, of course, the biggest piece of the Music Modernization Act was setting up this brand new method of paying music publishers who would then pay songwriters. The history of mechanical royalties has always been it's a fee that gets paid to the music publisher who then shares it with the songwriter. And typically on minimum, it's a 50-50 split. Sometimes the songwriter might negotiate a greater percentage of that. But the reason that the MMA was required is that we had a mechanical royalty provision passed in 1909. And that provision was actually passed because of piano rolls, mechanical devices that reproduced songs. And at that point, basically, if you wanted to use somebody's composition, you had to track down one publisher, tell them you were going to use it, and then pay them 2 cents for every copy that you distributed. And then, that provision worked okay when we moved to 78s and then to LPs and CDs. It was not very hard for a record company putting out a record to track down however many publishers there were. They were, obviously recording those compositions. They found them from music publishers or songwriters. So, they could track them down. So it was a pretty easy process. Where we got into problems was that in 2005, the publishers and the record labels agreed that in these new on-demand services, we would now have a mechanical royalty. So you take Spotify, you take Apple, or any of these other digital services who are ingesting millions and millions of songs, not 12 songs on a CD or 60 songs on a box set, but millions of songs. And the requirements of Section 115 were, before they streamed any of those songs, they had to track down every single publisher and send them a notice 30 days in advance. And it wasn't working. And Spotify kept getting sued, class action after class action, by publishers who weren't notified or weren't getting paid. There was one lawsuit brought by Eminem's publisher saying Spotify said they can't find us. Pretty ludicrous. So this was a fix for the services, and the services needed it so badly that for the first time, I think, in history, the users of music, Apple, Spotify, Tidal, Google, agreed to actually pay the costs of a new organization that was going to be formed to collect all the royalties and then pay out these royalties to music publishers. So the MMA was unanimously passed in the House and Senate in 2018. And it directed that this new organization be up and running by January 1 of this year. You can only imagine the difficulties of setting up a brand new organization. During last year, it's been a very difficult work. They are up and running. It is a remote company, but I will tell you, Sound Exchange, the organization that I started in 2000 and ran for 10 years, has been working remotely, and they're still getting royalties out the door. It's fortunate that it is work that can be done, remotely. So the MMA created to play on those records. Similarly, this organization started, and there was actually a proceeding, and it's overseen by the Copyright Royalty Board. The Copyright Royalty Board, basically sat down with, both sides, the users and the music publishers on the other, and songwriters on the other side. And they had to come up with a fee to create this organization. And it was a little over $30 million that was paid in. I wished I'd had $30 million in the beginning of Sound Exchange to build an organization, but they've had substantial resources to build it. Clearly, they have $424 million that they'll have 3 years to figure out who to pay it to. And one of the really controversial areas is, what do you do when you can't track people down? What do you do when people don't come forward? We certainly had the problem at Sound Exchange, and this problem will persist with the Music Licensing Collective. Typically they're market share distributions, so that the biggest publishers will get the most money out of that, and the smallest publishers will, again, it'll follow market share. The Copyright Office is holding some roundtables. If you have an interest in this situation, you should definitely check. They're typically called either black box royalties or unclaimed royalties. And I think, one of the things that's really important in the Music Modernization Act, and again, because Sound Exchange is somewhat of a model for this organization, I would get calls and they'd say, "How did you do this? How did you do this?" And on the payment, I advise them that they shouldn't be doing a pool release of these unpayable monies for at least, while 3 years is in the statute. I said it should be at least 5 years. You really need to give yourself time, even though you're going to have many more employees than I had, and you have greater technology available 20 years later in terms of fuzzy matching and all sorts of other algorithms. It's still, the goal should be to make sure you pay the right people. Typically one of the biggest areas of problem when it comes to these unmatched or bad data. Bad data is kind of separate from not knowing what the splits are. Splits are how much each writer of a composition and how much money their publisher should be claiming. And that typically is a much bigger problem in urban and hip hop music than it is in pop or country or rock. There's just many more participants. Oftentimes there's maybe a remix where a piece is added.
Yeah.
So there have been
and
a lot
sampling.
Yep. Well, and then sampling, is its own issue where someone's claiming a piece of the of that as well. But that can be on the composition side, and it also started to creep into Sound Exchange on the recording side, where a record label would say, "Hey, our sample's being used, so we now want to collect X% of the label share." So, but these are issues that can be dealt with, and I think it's important to have principles. I've written about this and tried to basically say, look, unclaimed money falls into different buckets. There's money where a particular publisher either doesn't know about their rights, doesn't exist anymore, you can't find the songwriter, and they haven't come forward to claim their money, versus bad data, where the data that's coming in from a streaming service is just so horrible, there's no way you'll ever be able to figure out what they actually played. And those are two distinct things. One, we can actually identify what it is. The other is, something, who knows what that is? And I think when you get really bad data where you don't know, like, for example, in the early days of Sound Exchange, we got, the rates got set very late, and people had already been streaming music, and it was AOL and Microsoft and big services and Yahoo. And they sent us big checks of money, and they said, oh, but we didn't keep track of the data. So here's a check. We have no data to give you. And then our job was, well, how do we distribute this? Well, let's see what other kinds of services we can find that would have mimicked those, so that we can come up with some sort of a proxy for it that we think is reasonable. And obviously, we went to the Copyright Office and said, look, this is a problem that we have. They gave us this money with no data, and that's going to happen. And then when that happens, you've got to try to think creatively and come up with the best solutions to address those problems. So the MMA has a very good set of people who are on their Unclaimed Royalties Committee. It's 3 songwriters and 3 music publishers, and I trust that they will do a good job in doing their best to track people down, and then market share distributions, or rough justice, as I call it, maybe your final issue.
All right.
Yeah.
Thanks, John. We had a question from the audience about do you consider a stream a sale or a license, or is it sui generis?
All right, so it's an interesting question, and actually it depends on the kind of stream that it is. So if you signed a record contract as a recording artist, and you signed that contract before 2003 or 2005, more than likely that is a licensed use, and you're supposed to get paid 50% of whatever the record label collects. And there have been a number of class actions on this particular issue.
Yeah, M&M class action is the big one that went to the Supreme Court.
Right, and that was actually on iTunes downloads.
Right.
So M&M's.
Oh, that's right. That's right.
So M&M's before 2003, where the record companies hadn't put in that an iTunes download would be treated like a regular sale. Again, it was great that M&M's production company, did this and basically won this case, which also led to a series of class actions, because all of those pre-2003 contracts, roughly anything that predated iTunes, it was a license where you got 50% as opposed to getting, 12%. A much greater, and more fair result for the recording artist. This was similar, in that it was on streaming. And again, we're now, in contracts where most artists are going to get 16% of the record company's Spotify royalties or Apple royalties. Obviously, superstars are probably getting half or even more. And, they've just basically said, I'm going to own the recording and I'll let you distribute it and take 25% or whatever the deal they cut. But it is interesting, and there's a very big distinction made between the non-interactive stream, so a Sirius XM stream, or the old Pandora or iHeartRadio, where you couldn't get the song you want when you wanted it. Those were non-interactive streams, and those were seen to be like radio plays. And again, Sound Exchange would be the organization collecting it, and the good news for artists was 50% of the money was being paid to the featured performer. If it's an interactive stream, where it is an on-demand service like Spotify or Apple, that is seen as a sales substitute, and therefore is, well, again, it's going to be based on how recent your contract is, but in any new contract, that's going to be looked at as a sales substitute, and you're going to be subject to your royalty rate, whatever that is.
Okay, great, thank you. All right, I'm going to give us a little update on the class actions that are currently pending in the Southern District of New York involving Section 203 terminations, master recording, grants of rights in master recording. So this goes to the big issue of, whether or not artists will be in a position to get ownership of their master recordings under Section 203 of the Copyright Act. So the first case is Waite et al. Versus UMG, and the two cases were separately filed, one against UMG and one against Sony, both in the Southern District of New York. The UMG case is before Judge Lewis Kaplan, and there was a motion to dismiss initially by UMG, and there was an order on that. In the Sony case as well, there was a motion to dismiss that Sony filed, and the bulwark of both of those motions was that master recordings are works made for hire, and therefore they are excluded from the termination rights under Section 203 of the Copyright Act, because obviously the author is the employer and not, in fact, the person who created the work. So initially, in the UMG case, the decisions came out just about a year ago on, I think, March 31st, 2020. And in the UMG case, the court granted in part and denied in part the motion to dismiss. There are some subsidiary issues that come up, or ancillary issues in these cases. And one is about loan-out companies. And this is an important issue for practitioners who represent artists. And basically, UMG argued that if the artist didn't actually sign the recording contract with the distribution company itself, and they use their own loan-out company, meaning an entity that they set up that they used as their what we call loan-out company to enter into the contract, then they could not exercise their termination rights. And this is very important. So I think the practical lesson for practitioners is that if you have an artist that's signing a contract with a major label or even a small production company, you should have the artist sign that contract in their own name. And then if you want to direct royalty payments or payments to be assigned to a company that they have for their tax purposes, that's probably the best thing to do. Judge Kaplan ruled that if there is a loan-out company, that the artist cannot exercise termination rights. And I'm kind of simplifying this, but essentially I think that's the big takeaway. The other takeaway was regarding what we call gap grants, meaning that artists who signed an agreement. So Section 203 of the Copyright Act was effective for works that were made after January 1, 1978, the effective date of the 1976 Copyright Act. And there are lots of recordings that were made pursuant to recording agreements that were signed before 1978, but the recordings were created after 1978. The LLC cannot, someone just asked a question, and that went back to that question of loan-out companies. And no, the LLC cannot terminate. The right of termination is a right of the author. It's not the right of a company or an entity. So it's only authors that can exercise those rights. So that's a very important point that practitioners really need to be aware of. But anyway, back to the gap grants. So basically, the court, Judge Kaplan ruled that if your master recordings created in the gap period, meaning that you signed an agreement before 1978, but your copyrights were made after that date, that you cannot exercise a right of termination under Section 203. There's a very different analysis that applies under Section 304, which is the other section of the Copyright Act that deals with the ability to exercise what's called renewal rights and also to exercise rights of termination. However, the rules for work for hire under works created before 1978 is very different. It's the instance and expense test, which is the test that was used for the Bob Marley estate. And basically, you're not going to win in general. I mean, there could be some exceptions, but in general, if your contract says that it was a work for hire, and even as in the Bob Marley case where the contract didn't say that, but the copyright was filed as a work made for hire, you're not going to be able to exercise termination rights. Otherwise, the motion was denied, and this question of whether or not artists can exercise their rights of termination under Section 203 of the Copyright Act was allowed to move forward. And at this point, that case has actually been stayed pending settlement discussions between the plaintiffs and UMG Recordings. The same thing actually has happened in the Sony case. The Sony case is before Judge Ramos in the Southern District of New York as well. And I think the most important point in that case is that Sony tried to argue that small errors or errors as to dates or references to agreements and a notice of termination made the termination ineffective. And the judge disagreed with that and basically gave what I'll call a notice opinion that said that, you know, if the label is on notice that the artist is intending to terminate the copyright, that's good enough in terms of they're exercising their right of termination, and otherwise, likewise, did not grant Sony's motion to dismiss on the concept of work made for hire. And those are very significant things to happen in connection with artists' rights of recapturing master recordings. From a social justice standpoint, we know that many artists don't get paid a fair compensation by their record labels, either because their contracts are set up in a way that their royalty streams are very thin or very slim or essentially non-existent. And so this gives them a second opportunity, a second bite at the apple to try and negotiate with the label. Likewise, the Sony case is up for settlement. At this point, both of the cases were in a posture where there was going to be a determination of whether or not they were adequate for class action, certification of the class action. And it is at that point that both of these cases went into settlement, and the cases are currently stayed. I can say personally that I've served a number of these notices for some very well-known artists, and the major labels are negotiating with me now to do new deals. It's important to note that the statute allows an exclusive right of renegotiation to the grantee, meaning the original grantee that the notice was served on, or to the assignee, the current assignee of the original grantee, to negotiate a new deal with the author before the effective date of the termination. So after the effective date of the termination, the artist can basically go out and negotiate with anyone for a transfer of the rights or a license or anything that they want. But prior to the date, the effective date of termination, the only negotiation they can do is with the current holder of the rights. So yes, the labels are avoiding a final determination and thus precedent, but I think they're doing that because they felt that they were getting ready to lose and they didn't want to have that happen. And they are very actively renegotiating. When I've got just over the past 2 days, I've gotten letters from Universal saying that they were ready to negotiate, and another letter from Sony in the past month or so saying they were ready to negotiate with the artists when I sent these notices in. Very, very important. The dates, the timelines for terminations, for works granted, for works created or published before 1983. Basically, your time period for termination has already ended. So from 1978 to 1983, as of this date today, a work that was published or created after before today's date, you've already lost your right of termination. Your notice period has already elapsed, right? So what we're dealing with now is literally if a work was created or if it was published after March 5th, 1983, you've got a problem. You basically missed your right. And for practitioners, you should know that there's possibility of malpractice lawsuits if you're representing recording artists or book authors or photographers or anyone else who may have these rights. It's important that you're up to date on them because you've got to get those notices of termination in. Otherwise, your client is going to lose their opportunity for termination and possibly for renegotiation or for capturing ownership of their creative works. Also, to note that Section 203, the rights are for the author only. And so if you're the author and you're terminating now and you do a renegotiation with your existing record label or even a new company or your new a publishing company, in 35 years, you can terminate again or your heirs can terminate again. So it's a very interesting cycle that you can get into in terms of terminating. I'm working on one now for a woman who co-wrote the song "It's a Man's World" with James Brown, and I sent in her notice of termination, and we're doing her renegotiation now. She's an elderly woman, and actually, her heirs are going to be able to terminate again 35 years from now. So Section 203 is definitely very important for artists. We have a few more minutes. Bob, I don't know if you can speak briefly on the trademark issue that was in the Dr. Seuss case.
Sure.
Maybe you could do that. And then I've got one more question for John.
I can do that rather quickly. The trademark claim brought under the Lanham Act related to the use of trademarks in the book, in the defendant's book, and there's a test for that. It's based on Rogers v. Grimaldi, a 1989 Second Circuit case, which has also been adopted in the Ninth Circuit. And the test is that the trademark owner does not have an actionable Lanham Act claim unless the use of the trademark is either 1, not artistically relevant to the underlying work, or 2, explicitly misleads consumers as to the source or content of the work. And the test under the first part, artistic relevance, is any relevance above 0 meets the Lanham Act. And that is because the courts have said that we want to err on the side of the artistic expression. And if it does have artistic relevance, as it did in this case, then it can only be an infringement if there's an explicit reference to sponsorship or authorization by the trademark owner, and an implicit reference will not be sufficient. So if somebody says this is an authorized biography of, that implies the person who is the subject authorized it. But anything less than explicit references will not work, and survey evidence will not work, at least it did in this case. So,
all right. Very good, very good. John, one last question for you about independent publishers and artists who have their own publishing companies. Do you know what they need to do to register with the MLC? I mean, do you know the process now?
Well, I think it's pretty straightforward. If you go to the MLC website, as I mentioned before, it's THEMLC, and I think it's both .com and .org, but you'll obviously find it. And it, it's a pretty straightforward process, similar to the way you register with Sound Exchange. There's some documents you got to fill out. One of the other major pieces, by the way, Lita, that I didn't mention is that part of the act was to create, they have to create a database of who owns what, compositions. And I think that's a really major breakthrough because, ASCAP has a pretty big database you can search. BMI has a pretty big database you can search. They've actually just announced a combined database you can search. But it's always been a mystery, like who owns what and how do you find them and track them down. And so this is a major step in that direction. And obviously for all these independent publishers to get in the system and in the loop, another thing that publishers really need to make sure they're doing is getting ISWC codes Again, we have bad metadata in this business. We need to have better. ISWCs are essentially like a social security number for each composition.
Right.
And we need to have those, and they're easy to find.
Well, where do you get one, though? That's what a lot of songwriters want to know. How do you get the ISRCW number?
Well, the ISRC is for the recordings, and you typically get those through the Recording Industry Association of America, or if you're an indie artist, I know CD Baby was giving them out for a while. On the ISWC,
ISWC, right?
Yeah, I think you might be able to go similarly to the National Music Publishers Association, the NMPA, or you could go to CISAC. I know that CISAC has a whole, that's not CSAC, but CISAC, CISAC. .org, and that is the international organization that represents creators all over the world and is really trying to improve all the metadata so that people are getting payments when their work is being used.
Okay, great. Well, thank you, Bob and John, very much for participating, and we look forward to more updates from you guys in the future. Thank you very much.
Thank you, Lita, for inviting me.
Sure. Hi, Lateef. This is Lateef Matima, Mr. Bernstein. John Simson, I believe, knows Professor Matima, but Mr. Bernstein, he is the director of and founder of the Institute for Intellectual Property and Social Justice.
Thanks, Lita. It's great to meet you, sir.
Oh, good to meet you.
Really, that was a fantastic panel, and I think we are live in the back on stage. And about to make the transition. Let me just make certain of that. Can everyone else? Yeah, I see that we have a lot of people join. So I think that we are able to just immediately transition to the next presentation. But this was a fantastic panel presentation. And, over the course of the past 2 days, I've, on the one hand, been able to talk about how pleasant it's been to see IP lawyers who I first knew at the start of their careers and perhaps had some hand in helping to educate them and bring them into the field. Lita Rosario, being a contemporary of mine, of course, graduated from Howard before I joined the faculty. And so with Lita, we have a reversal because from the first time that I met Lita Rosario, she has been teaching me about entertainment law year after year after year. And I think the work that all of you are doing is absolutely fantastic. And in particular, the termination work, as we noted in the chat, there are so many developments now that are being beneficial to artists and other creators. So thanks very much. With that, I believe that we are ready to make the transition to the racism and branding panel.